We will now continue with the discussion on negotiable instruments. So today we'll be discussing the remaining two sections from sections 1 to 10. If you notice, we have already covered 1 to 10 except your sections 5 and 6. Section 5. Section 5 refers to what we call as additional provisions not affecting the negotiable character of your instrument. Your section 6, on the other hand, are omissions that will not also affect the negotiable character of your instrument. So going back to your section 5, additional provisions not affecting the negotiability. As a general rule, you have to take note that your instrument should only contain an unconditional promise or order to pay a sum certain in money. That you should not be required to perform any other act besides the payment of money. So take for example, in this illustration, I promise to pay to bearer 100,000 pesos and to deliver to him a motorcycle signed A. This portion, and to deliver to him a motorcycle, the maker now, Mr. A, is being required to perform any additional act besides the payment of money. So if this instrument should have been only to state that I promise to pay to bearer 100,000 signed A, there is no question that instrument should have been a negotiable instrument. However, with the inclusion of this phrase, and to deliver to him a motorcycle, that instrument now becomes a non-negotiable instrument. Why is that? Because there is now an additional obligation to pay other than to pay a sum certain in money. But you have to understand, under Section 5, there are at least 4 instances whereby the maker of the drawer can be compelled to pay or to perform an additional act besides the obligation to pay a sum certain in money, but the instrument would still be considered a negotiable instrument. So the first one is when it authorizes the party primarily liable to sell collateral securities if the instrument will not be paid on maturity. Next one would be authorizes confession to a judgment if the instrument will not be paid on maturity. The third one would be waives the benefit of any law intended for the advantage or protection of the obligor. And finally, gives the holder an election to require something to be done in lieu of the payment of money. So in all those 4 cases, even if the instrument contains a provision requiring the performance of an act besides the payment of money, the instrument would still be considered a negotiable instrument. So let's take a look at the first exception. So authorizes the sale of collateral securities in case the instrument will not be paid on maturity. As of this early, I want to emphasize that this additional obligation, which is to sell collateral securities, will happen only if the instrument will not be paid on maturity. In other words, prior to maturity or on maturity, there is only one obligation that will be performed by our maker or by our acceptor. That is the obligation only to pay a sum certain in money, considering that this additional obligation, which is to sell collateral securities, will come into play only if the instrument will not be paid on maturity. So let's take a look at this illustration. I promise to pay Peter or order 1 million pesos on January 1, 2020, signed by. Okay? So if you notice, on January 1, 2020, or in any day earlier than January 1, 2020, the maker, Mike, will only be required to perform one act. And what is that? That is to pay only 1 million pesos. However, if you notice, there is also this second paragraph or second sentence, which states that in the event that I will not be able to pay on the due date, I hereby authorize you to foreclose the real estate mortgage constituted over my house and lot. This additional obligation of mine, which is to allow the foreclosure of the real estate mortgage, will happen only if there is failure on his part to pay the amount of 1 million on January 1, 2020. So again, to reiterate, before January 1, 2020 or on January 1, 2020, Mike has only one obligation to do. That is to pay only some certain in money. And what's that some certain in money? The payment of 1 million pesos. However, if Mike, for one reason or another, will fail to deliver the amount of 1 million pesos to Peter or order on January 1, 2020 or on any day earlier than January 1, 2020, then there is now an additional obligation that will be performed by Mike. That is to give his conformity to the sale of his house and lot, which is the subject matter of a real estate mortgage. Now, will the inclusion of the second paragraph or second sentence affect the negotiable character of your instrument? The answer is no. Why is that? Because take note, this obligation to sell or authorize the selling of collateral securities in case the instrument will not be paid on maturity is an additional provision which does not affect its negotiable character. Why is that? Again, without the necessity of being repetitive, this additional obligation of selling collateral securities will happen only after the due date. It does not happen before the due date. It does not happen on the due date or on maturity. So, ladies and gentlemen, what is the lesson that can be lifted from here? The lesson is that as long as on maturity or before maturity, your only obligation is to pay some certain in money, you will not be required to perform any additional act besides the payment of some certain in money. The instrument is considered a negotiable instrument. It does not matter anymore if after maturity, you will now be required to perform any additional act besides the payment of money. Second exception authorizes a confession of judgment if the instrument will not be paid on maturity. Take note again, this obligation to confess to a judgment will happen only after maturity if the instrument was not paid on after maturity. I want you to remember that confession to a judgment is generally not allowed in the Philippines because that is contrary to public policy. However, confession to a judgment in a civil action, or what we call as cognovit actionem, is actually allowed because such as authorizing the plaintiff to sign a judgment for a certain sum after a suit is brought. That's what we call as cognovit actionem, and that's allowed in the Philippines. Therefore, this confession to a judgment, if the instrument will not be paid on maturity, shall be viewed from that angle that it is just a cognovit actionem. It does not apply to confession to a criminal case because it will now violate our constitutional prohibition that every person is presumed innocent unless his guilt is proven otherwise, unless his guilt has been proven beyond reasonable doubt. So let's take a look at this illustration then. I promise to pay Peter or order 1 million pesos. If I will not be able to pay on the due date, I hereby bind myself to pay damages and cost of collection. Signed, Mike. So if we will only consider the first portion of the instrument, I promise to pay Peter or order 1 million, signed Mike, there is no question that Mike, the maker, will only be required to perform one act, that is to pay 1 million pesos, to pay some certain in money on the due date or on the due date, on the due date or before the due date. Okay? But after maturity, if the instrument has not been paid by Mike, then he will now be required to perform an additional act besides the payment of 1 million pesos. And what is that additional act that Mike is required to pay or is required to do? That is to pay damages. That is to pay the cost of collection. Well, will the inclusion of that second sentence now, if I will not be able to pay on the due date, I hereby bind myself to pay damages and cost of collection, render the instrument non-negotiable? Obviously, the answer is no. The instrument remains to be a negotiable instrument, even if the maker is required to perform an additional act besides the payment of money. Why is that? Because that additional obligation comes into play only if the instrument has not been paid on maturity. That additional obligation will be enforced only if that 1 million pesos has not been paid on time. Okay? Okay. So we'll continue with the discussion. Next. The third one would be waives the benefit of any law intended for the advantage or protection of the obligor. So in this situation, besides the payment of money, the maker or the acceptor now is being required to perform an act of waiver, okay, intended of a law which was designed for the protection or advantage of the obligor. The obligor being referred to here is the maker or the acceptor himself, the person primarily liable. So illustration, I promise to pay Peter or order 1 million pesos. If I will not be able to pay on the due date, I hereby waive my right to object to the rule on venue. Signed, Mike. Venue refers to the place where the action is to be instituted. And our rule is that if it is a personal action such as this one for collection of sum of money, then the venue would be at the place where Mike or Peter are residing. So if assuming that Peter is a resident of San Fernando, La Union, and Mike is a resident of Baguio, in the event that Mike will not be able to pay the amount of 1 million, then the case for collection of sum of money can be filed by Peter either in San Fernando or in Baguio City, as the case may be. But in this situation, Mike, in addition to the promise to pay 1 million, he likewise indicated that if he will not be able to pay on the due date, then he will now waive his objection to the rule on venue, to the place where the action will be instituted. So with that, is it possible now for Peter to file in any place, in any other place besides San Fernando, La Union, or Baguio City, as the case may be? Then the answer would be yes, because Mike has practically waived his right to that rule on venue. Anyway, venue can be waived also. Venue is not jurisdictional when it comes to civil cases. It can be waived. Parties can choose, especially if there has been waiver of that rule on venue. But how about in this situation? I promise to pay Peter or order 1 million pesos with a daily interest of 30% until fully paid. If I will not be able to pay on the due date, I hereby waive my right to object to the imposition of daily interest of 30%. Signed, Mike. Still, similar, I promise to pay Peter or order 1 million pesos, some certain in money. And then it says here that besides payment of 1 million, there will also be imposition of this outrageous interest of 30%, daily interest of 30%. But Mike waive his right to question the imposition of the daily interest of 30%. While it is true that pursuant to Central Bank Circular number 905, there is no more usury law. So debtor and creditor can now agree on an interest higher than the legal rate of interest. However, pursuant to jurisprudence laid down by the Supreme Court, such as in the case of Medel versus Court of Appeals, the agreement for an interest shall not in any manner be considered as iniquitous, unconscionable, contra bonus mores. Such as in the case of Medel, whereby the agreed rate was only 5.5% per month. Supreme Court declared the same as illegal because the interest of 5.5% per month is considered as iniquitous, unconscionable, contra bonus mores, or it's against morals. Now, how about if in this situation where the maker himself waive the right to question the legality of the interest rate of 30% daily? Will that be considered as a valid waiver of that right or of that benefit accorded to Mike by law? The answer is no. It's non-negotiable. Why is that? I want you now to take note of the last paragraph of Section 5. Anong sinabi niya doon? But nothing in this section shall validate an act otherwise illegal. So what does that mean? That although the obligor here, the maker in this promissory note, has waived his right to object to that daily interest of 30%, that waiver shall not be allowed because you are now validating an act which is already considered illegal. Ano ba ang illegal doon? The imposition of interest of 30% daily. Being iniquitous, unconscionable, contra bonus mores, that is already illegal. And you cannot waive a right if to do so, you are giving validity to an act which in the first place is already illegal. It is illegal to charge an interest of 30% daily. Now, if I will waive that, then I am now giving validity to an act which in the first place is not allowed under the law. Going on further. The last one gives the holder an election to require something to be done in lieu of the payment of money. In this situation, the maker or the acceptor is being required to perform an additional act besides the payment of money. However, the election, the right of choice is conferred on the maker. The right of choice is conferred on the acceptor. So take for example in this illustration, pay to birth or order 10,000 pesos or 50 kavanes of rice at the option of the holder. To Alex, signed Alan. In this situation, you notice that besides the payment of 10,000 pesos, Alex, the drawee acceptor, has the option of delivering 15 kavans of rice. Take note, it's not Alex pala. It's not Alex. Rather, it is the holder. Okay? It is the holder, the possessor of the instrument, who has the option of asking the delivery of 15 kavans of rice. Okay? So this is considered as negotiable. How about if this is the situation? Pay to birth or order, 10,000 pesos and 15 kavans of rice at the option of the holder. To Alex, signed Alan. If you notice, ano lang pinagkaibahan? Yung conjunction lang. Yung isa or, ito and. Negotiable or non-negotiable. In this case, it is non-negotiable. Because even if there is this phrase at the option of the holder, it is not really an option. Kasi nga, ang ginamit na conjunction is and. So, holder here has no choice but to ask for the delivery of 10,000 and at the same time, 15 kavanes of rice. Another situation, pay to birth or order 10,000 or 15 kavanes of rice at my option. To Alex, sign Alan. It's or, but at whose option? At my option. Sino si my option? At the option of Alan. At the option of the drawer. That being the case, our instrument is considered non-negotiable because it is not at the option of the holder or possessor of the instrument. So again, I want to reiterate, gives the holder an election to require something to be done in lieu of the payment of money. In this situation, it is the holder or the possessor who has the right to choose which of those subject matters will be delivered by the person primarily liable. Ano ba ang ibibigay ni maker? Ano ba ang ibibigay ni acceptor? Hindi si acceptor, hindi si maker ang pipili. Hindi si drawer ang pipili kung ano ang ibibigay. Ang pipili kung ano ang maibibigay is the possessor or the holder of the instrument itself. Section 6, omissions. So kung yung isa dagdag, ito naman kabawasan sa instrument. The validity and negotiable character of the instrument is not affected by the fact that, first, it is not dated, does not specify the value given or that any value has been given, therefore, does not specify the place where it's drawn or the place where it's payable, and bears a seal and designates a particular kind of current money in which the instrument is to be made. Yung first na situation, when it's not dated, we have made an ample discussion on that when we were still in determinable future time. Okay? So take for example, it is not dated. Illustration, I promise to pay Peter or order 1 million pesos, signed Mike. There is no date of the instrument, no date of issuance. Is this considered a negotiable instrument? The answer is yes, as we have said before, because if there is no date, the instrument under section 17, third paragraph, it is presumed to be dated on the date it was issued. So if the instrument, this promissory note was issued today, then you have to place the date September 15 because that's the date of the issuance of the instrument. Next one. Does not specify the value given or that any value has been given therefore. Ano ba yung sinasabi dyan na value given? Okay, let's illustrate. Ito yung sinasabi niya na value given for value received. You might have noticed that in our previous examples, whenever I make a promissory note, I always make use of this phrase. I promise to pay Peter or order 1 million pesos signed Mike. I never made use of this phrase for value received. So, because even if I will omit this phrase for value received, the instrument would still be considered a negotiable instrument. You might be wondering, ano ba kasing implication ng phrase na for value received? For value received, short of saying that Mike is giving a promise to Peter to pay the amount of 1 million because he has received valuable consideration from Peter. It is possible that Mike obtained a loan from Peter the amount of 1 million. That's why he is saying to Peter, or to the transfer of Peter, that he would pay the amount of 1 million because he has earlier received valuable consideration from Peter. What is the justification? What's the legal basis? Why I am allowed to remove this phrase for value received? Bakit? Because of section 24. Ano ba yung sinabi doon sa Section 24? Section 24 provides that every negotiable instrument is deemed prima facie issued for a valuable consideration. Prima facie. There is a disputable or a rebuttable presumption that every instrument has been issued for a valuable consideration. That even if this phrase for value received has been removed or omitted, there is a presumption that Mike has received valuable consideration from Peter. That's the reason why he is giving a promise to pay Peter or the order of Peter the amount of 1 million pesos. And you might be wondering, ano ba yung value na pinag-uusapan natin dyan? For value received, what is that value? Section 25 of the Negotiable Instruments Law refers to what we call as value. Valuable consideration. Valuable consideration refers to any consideration sufficient to support a simple contract. And it could even be a pre-existing obligation. Utang. Kaya yung sinasabi ko sa inyo kanina na si Mike, merong utang kay Peter. Kaya niya binigay yung promissory note na yan kay Peter. That is covered now by the phrase for value received. But again, there is no necessity to still indicate the phrase for value received because of the presumption, the disputable, the rebuttable, or the prima facie presumption found in Section 24 that every instrument was issued for a valuable consideration. Going on further. Does not specify the place where it's drawn or the place where it is payable. Place where it was made as well as the place where it is to be paid. Illustration. Okay, so Quezon City, January 20, 2020. I promise to pay Peter or order 1 million in Makati City, Philippines. Signed, Mike. Quezon City is the place where it was drawn and it was made because this is promissory note. So Quezon City is the place where it was made and Makati City is the place where it is to be paid. But even if I will omit this Quezon City as place of issuance, under the Negotiable Instruments Law, there is again a presumption that this instrument was issued at the place where it was dated. And where is the instrument presumed to be dated? At the place where it was issued. Okay? And how about Makati City? Is it possible for me to omit again the place of payment? The answer would be yes. Why is that? Because under Section 73 of the Negotiable Instruments Law, there is again a presumption that the instrument is to be paid first at the place where it has been agreed upon by the parties. Sir, halimbawa po, wala pong place agreed upon by the parties. Where will I now deliver the payment? If Mike, the person primarily liable, indicated his address, then payment shall be given at that place of Mike. If Makati City was omitted, the address of Mike was likewise omitted. Where will I now give the payment? Sabi doon sa Section 73, anywhere else you can find the person. So anywhere else I can find Mike, I can demand payment from him. So even if Makati City, the place of payment was not specified in the instrument, it's still a negotiable instrument because the place of payment is actually covered by our Section 73. Going on further, there's a seal. There's a seal. So even if the instrument has ang tawag nyo dito? Hindi to seal. This is what we call as, basta, yung tawag dyan, nakalimutan ko. Yung 7-Eleven, ito yung letterhead ng 7-Eleven. So, letterhead ng 7-Eleven, 7-Eleven Corporation, Makati City, Philippines, I promise to pay Peter or order 1 million pesos, signed Mike, 7-Eleven President. Now, in this particular situation, even if this promissory note bears this seal of 7-Eleven, this letterhead of 7-Eleven, the instrument is still considered a negotiable instrument. Okay? But in the olden times, ang sabi, if the instrument has a seal, the instrument is now considered non-negotiable. Okay? So that was in the olden times. And finally, designates a particular kind of current money in which the instrument is to be made. You notice that in our examples, I usually make use of Philippine currency. So I promise to pay X order 1,000 pesos on demand. Ganun. 1,000 pesos. That's Philippine currency. But is it possible for me to make use of different currency besides Philippine peso? The answer is yes. And it does not affect the negotiable character of the instrument. Such as in this case, instead of using Philippine peso, I made use of US dollars. Negotiable pa rin po yan. So next one, we will now have our activity. Kapag nag-live tayo, pag-uusapan natin itong mga activities na ito. So, this will now be the last part of our discussion of sections 1 to 10. Sabi ko noon, be ready. Meron kayong naka-ready na activity. Quiz po ang ibig sabihin nun. Magandang araw po sa inyong lahat.